Hello everyone, welcome, and thanks for joining us today for the training on our legal clinics. So we're looking forward to working with you at our clinics, and we're going to take about no more than an hour of your time today. Hopefully we'll finish on time. My name is Kate Richardson, and I am the Pro Bono Manager and Staff Attorney here at Swords to Plowshares.
And this is Mo Cedor. I'm the Pro Bono Fellow and Staff Attorney here at Swords.
Great, so let's get started. So just a brief agenda of what we're going to cover in this next hour. We're going to do a brief review of VA benefits and eligibility. Then we're going to jump into compensation. We'll quickly cover what veteran status means. We'll talk about the 3 elements of service connection. We'll talk about rating, and then we'll move over to the claims procedure, some clinic logistics, what forms you'll be filing, things to keep in mind, and we'll finish with a little bit of cultural competency with working with veteran clients. So before I dive in, I just want to take a minute and tell you a little bit about Swords to Plowshares for those of you that are unfamiliar with us. We're a veteran service organization based here in San Francisco, and we were founded in 1974 by returning Vietnam-era veterans who really saw this need in society and by the VA not being met for its current veterans. So with that in mind, we offer holistic services. We have transitional housing, permanent and supportive housing for veterans. Last year alone, we provided housing assistance to over 900 veterans in the Bay Area. We also have health and social services, so we have social workers on staff, case management. We have an employment and training program. And then our Institute for Veteran Policy, IVP, does a lot of national level policy work and litigation work around issues that affect veterans. Finally, last but not least, in our legal services department, where we work, we offer free legal services to veterans on VA benefits issues and military discharge upgrade issues. Last year we provided free legal services to over 400 veterans through our staff attorneys here and also through our pro bono program. So clinics are really a key way that we provide those services, and likewise our clinics offer services for VA benefits and discharge upgrades. So let's talk a little bit about what benefits are available through the VA and get into eligibility. So when you hear VA benefits, that general term refers to many different types of benefits. One, and in my opinion the most important and what we'll be focusing on today, what we work on in our legal unit, are the cash assistance benefits. So these are the 2 items in blue, either service-connected disability compensation, and then there's also non-service connected pension. Those are very different. We won't dive deep into pension today. We will see pension applications come through our clinic. It's very straightforward. It's an application. There's minimum eligibility requirements that you meet. If you sort of meet those requirements, you're in. Compensation is where advocates make a huge difference in the lives of veterans. Other VA benefits, education, I'm sure many of you are familiar with, being students yourselves. The GI Bill, that's a major VA benefit. Healthcare, obviously it's the largest integrated healthcare system in the country. There's home loans through the VA, there's life insurance, and of course there's burial and memorial services. So let's talk about what it means to be a veteran. Many people, and many of you might not know, many people are confused by this, that veteran status is a specific definition that's promulgated by the United States Code. You'll see up here 38 U.S.C. 101-2. As a person who has served in the active military, naval, or air service, and who is discharged under conditions other than dishonorable. Now that would be nice if that were a clear-cut, easy definition. It's one sentence. However, when we unpack that one sentence, there's actually a lot of different eligibility criteria that a veteran has to meet in order to receive the benefits that they should be entitled to and deserve. And the way this breaks down, I'll talk about these briefly, but for your purposes, at our clinics, because we work in partnership with the VA and they provide the space for us to hold these clinics, most of the folks we see have already overcome this hurdle, so to speak. So most of them have already been deemed veteran status by the VA. But it's important for you guys to be aware of this, so I want to briefly touch on these. It has to be federal, so Army, Navy, Air Force, Marines, Coast Guard. One thing to keep in mind, if it's National Guard, only if they were federalized and called up to service. So if you're National Guard and your state governor calls you up to fight a forest fire, you are not federal service. However, if ordered from the president to go serve in Iraq or Afghanistan for 6 months, then you were federalized. Active, this is just, it needs to be active duty, so reserves, do not count as veteran status only if they were mobilized. There's also a minimum time and service requirement for periods of service after 1980, that is 2 years of service, or the full-time ordered to active duty. So if someone was called up for active duty for 1 year in Afghanistan and they completed that time, just because they're under that 2-year mark, that's okay. They did what was asked of them, therefore they completed that full-time order to active duty. Now, one very important exception that occurs here that you all will see a lot and that affects a lot of our work at the clinics and here at Swords to Plowshares is that this minimum time and service requirement is waived when we're talking about a service-connected disability. So that's detailed under 38 CFR 3.12a, and basically what that means is if somebody serves for 8 months, a period of 8 months, and incurs an injury or disability during that time, they can go ahead and claim for a service-connected disability compensation and be considered veteran status despite the fact that they have not served the full 2 years. We'll get into more of that later, but there's also some statutory bars. You definitely will not see these at the clinic, but there are some to be aware of just for your own knowledge. And then finally, here's the big one, honorable service. You remember that definition up at the top, other than dishonorable. It would be really nice and easy if there was just 2 different discharge statuses, dishonorable and honorable. However, that's not the case. We actually have 6 different levels of discharge. So when someone gets separated from the military, they're given discharge papers, what's called a DD-214, that will list their character of discharge. And that could either be honorable, general under honorable conditions, uncharacterized, other than honorable, or what we refer to as OTH, a bad conduct, or dishonorable. And so depending on where they fall on that, within those 6 different levels of discharge, they may or may not be called a veteran for the purposes of VA benefits. So the VA may deny them benefits for their service-connected PTSD. They may have fought in combat in Afghanistan, in Iraq, come home and received an other than honorable discharge and are barred from receiving benefits. So that is a process that we call character of discharge determination. It's made through the VA, and it's where advocates and attorneys can play a huge role in the lives of veterans in order to get them eligible to get the service-connected disability compensations. So this doesn't actually change what's on their DD-214. This is not a discharge upgrade. This is a separate process through the VA called the character of discharge determination process. So that's basic eligibility. Again, you won't need to know this in and out, so don't feel overwhelmed by this, but it's good for you to sort of be aware of these different criteria and these different factors, and why calling someone a veteran or asking if they're a veteran often carries much more weight and a different connotation than you might think. So let's briefly cover service-connected compensation. Now at this point, I hope that you've all found time to complete in your busy schedules, the 3 hours of our PLI training that's available for free online, broken out by the hour. If you haven't yet done so, I'd encourage you to do that as soon as possible, and definitely before you staff your first clinic. So this should all be a review, but I'm going to spend a little bit of time just quickly reviewing so we're all on the same page. So what is compensation, or VA? When I say compensation, I mean service-connected disability compensation. The purpose of compensation is really to compensate a reduction in earning capacity caused by the service member's military time in service. These are monthly payments, and they're tax-free. So this is a major benefit. This is actually the highest amount of a federal benefit that anyone is eligible for. So this is not means tested. Unlike pension, which is much like other benefits like Social Security, you have to be under a certain income level. Once you're over that, you're no longer eligible for that benefit. Service-connected disability compensations are not means tested. So you could be, say, a veteran makes 50, 60 grand a year at their job. They can still, on top of that, be getting these service-connected disability compensation payments. So it's really an important benefit. They're awarded based on a degree of disability. So the VA will look at the current disability and assign that veteran on a scale between 0 and 100% in increments of 10. So let's take a little deeper look into that degree of disability. So this is laid out in the regulations. It's also on the VA website. These compensation rates, they change every year. And you'll see it goes up by 10%, and it's related based on the degree of disability. You're then assigned a certain monetary value. So if you're deemed 50% rated, 50% disabling for post-traumatic stress, then the VA will be paying you a check. In addition to giving you health care for that condition, they'll be giving you a check of $822 a month in tax-free payments. One thing that I want to point out to you is this is not linear. You'll see that it jumps dramatically once you hit 90%. The difference between 90 and 100, even 60 to 70, it starts to jump up in those higher percentages. And so a lot of our work as attorneys and your work as law students will be to support ratings increases for our clients. So let's say the VA has come back and given them a 50% rating for their post-traumatic stress. However, their symptoms are very severe. They're severely impacting their life. We will do a lot of advocacy around proving to the VA or showing the VA what necessary evidence they need to see that says actually this veteran is suffering a great deal from this disability. Yes, it's service-connected. We've already decided that, but you know what? We really need to reevaluate, give them a new exam, and perhaps determine that that veteran is 100% disabled or even 70% disabled for that post-traumatic stress. So this is just something to be aware of. This is where a lot of our roles as advocates and hopefully your roles as future advocates for veterans will come in. So elements of service-connected disability compensation. We already talked about veteran status. So if we need to go through the character of discharge determination process, let's say our attorneys have helped our clients do that at the clinics. Now we move on to the actual service connection. You'll remember from the PLI training there's 3 different elements. So there's you have to have a current disability, so current diagnosis of PTSD, a current diagnosis from a doctor about a shoulder injury, etc. There has to be some current impairment. Then that in-service event or injury was either incurred or aggravated during service. So you developed PTSD during service, you had a shoulder injury during service from an explosive device, etc. Now it can be aggravated as well, so just because someone, say, had a pre-existing knee injury, if that knee injury was made worse during service, we can also get them connected for that. Finally, there's a nexus element, which just means that that current disability is as likely as not related to that in-service event or injury. So once we have met our evidentiary burden for all of those service connections, then we move on to a rating, and the VA then assigns a rating, which is an evaluation of that present impairment, which we just discussed. So that is sort of service-connected disability compensation in a very brief nutshell. Again, I hope you watched the PLI training, and if not, let us know. With that, I'm going to turn it over to Mo to give you a bit of context about VA claims procedure.
Thanks, Kate. So I'm going to go over the process that a VA benefits claim goes through, and the reason this is relevant to the work of law students at our clinics is because we'll be asking you guys to help file claims that are at various stages in the claims process. So it'll be good to have some context into the different types of claims that we file at with the VA, the different venues that we file those claims at, and the process that a claim goes through from that initial step all the way to the appeal. So to begin, these are the venues that a VA claim may be found at. So we have 53 regional offices. The regional office is, 53 regional offices across the country. This is the agency of original jurisdiction, so initial claims are always going to be filed with the regional office. In the Northern California area, we have our regional office in downtown Oakland in the Federal Building, so that's where we'll be faxing and filing those initial claims. The next step is the first level of appeal, which is at the Board of Veterans Appeals, or the BVA. If a claimant doesn't prevail at that level of appeal, then the next one is the CAVC, the U.S. Court of Appeals for Veterans Claims. This is a Article I court, and the first time you'll be in an adversarial setting as a claimant. Again, and then if you're not, if you don't prevail at that level, then the next level is the U.S. Court of Appeals for the Federal Circuit, and from there, the U.S. Supreme Court. We do most of our advocacy and work at SWORDS at the VARO, the VA regional office level, and at the BVA, and that's because that's where we win most of our cases, and that's where we do most of our work. So what are the different types of claims that one can file with the VA? To begin, there's the original claim. So this is for a veteran who's never filed for a VA benefit before, never filed for compensation or pension. They'll be filing an original claim with the VA. Sometimes there'll be we'll get veterans through the clinic who've already been service-connected for some sort of injury or condition, but they want to get a different injury or condition service-connected. That would be a supplementary claim. That would be an example of that. So say, for example, they've already gotten service-connected at 20% for their right knee, and they now, 3 years later, want to get service-connected for a wrist injury that happened in service. we'll help them file a supplementary claim for that new wrist injury. And there's no issue with that. There's no problem filing years later for a new injury. You don't have to file everything all at once. Another example of a supplementary claim is a secondary service-connected injury. So an example of that is, say you've been service-connected already for your knee, and as a result of that knee problem, you've developed a hip problem. You can request service-connected compensation for that hip problem that's secondary to your already service-connected knee problem. So that's another thing that we get through the clinic as well. And then for closed issues through the VA, you can reopen a claim. So say you got out of service, right out of service you filed for PTSD service-connected compensation, you were denied, and 10 years later you come through our clinic doors and you want to file for PTSD service connection again. That's no problem. We can absolutely help the veteran with that claim. There's a small hurdle you have to pass, which is that you have to supply the VA with new and material evidence. So new evidence is anything that the VA didn't consider the first time that they evaluated that claim. And then material evidence is any evidence that speaks to the reason why the claim was initially denied. So in the example of a PTSD claim, say they denied it 10 years ago because there was no indication of an in-service stressor. The client comes to us through our clinic. We can help them draft a stressor statement to speak to the reason it was denied in the first place, to establish that in-service stressor did occur. And of course, it will be new evidence that the VA didn't consider the first time. Another kind of issue that we'll see, and this is rare, but it's good to know about, is clear and unmistakable error. That's when a claimant filed a claim back in the day, the VA evaluated it, and say, for example, the VA, in their evaluation of that claim, applied the incorrect legal standard or an outdated regulation. And the veteran comes to our clinic and wants help filing that claim again. We can request their claims file. If we see that the VA messed up and they applied the wrong standard or the wrong law, we can request that they do a reevaluation of that veteran's claim. And these are great cases because if the claimant does prevail, if we do prove that the VA did mess up back in the day, they can get a back paycheck to when they originally filed. So it can be decades ago. So that can be really great for a veteran. And then this is probably the most common type of issue of these last three that we see through the clinic doors, and that's a ratings increase. So that's when you've already been service-connected, say you're at 50% for PTSD, and your condition has worsened, your symptoms have worsened, and you want to be rated at a higher percentage. We can help a veteran apply for that ratings increase at any time. So those are kind of a brief review of the types of claims we see. Now we're going to go through the process that a claim goes through. So for a brand new claim, the first thing we want to do as advocates, and what the attorneys will be doing at our clinics, is helping veterans file informal claims. And those will be on VA Form 214138. And it basically, it says on the form, this is an informal claim for service-connected compensation for whatever the condition is that the veteran wants to get service-connected for. So the reason that this is very relevant to you guys and why it's so important to how you'll be helping these veterans is that this informal claim establishes the effective date for the claim. So right now, the VA claim process can take, a year and a half, sometimes more. Say at the end of that process and the VA does their evaluation of all the evidence and everything we've submitted, and the claimant prevails and gets service-connected at 70%, what happens is they'll start receiving that tax-free monthly payment that Kate talked about, but they'll also get a back paycheck all the way back to that effective date, so the date that they filed that informal claim. So for the purposes of clinic work, it's always important to flag all those informal claims that we get from clients and fax those and file those immediately so we can start the ball rolling and establish that effective date. So once we get that informal claim in, the veteran then has 1 year to file their formal claim. So in this year, we'll request VA medical records, any private medical records, military personnel records, in-service military records. will pull any relevant evidence from those records to support their claim. The attorneys can write up advocacy briefs convincing the VA why that claimant should get service-connected compensation for whatever the condition. And then within a year of filing that informal claim, file all of that evidence with the VA with the formal claim application. So once that's in, then the ball is in the VA's court. They'll review everything that the veteran or the veteran's attorney has submitted on their behalf, the advocacy brief. They'll do their own records request, review the records on their own, and if the claim they deem has merit, they will schedule a compensation and pension exam for the veteran. And this is basically a medical or mental health exam that the veteran attends, and the doctor will then evaluate whether the condition is service-connected or not, and at what rate the condition disables the veteran. The VA then will take into consideration the results of the comp and pen exam and all the evidence submitted, and they'll come up with their decision, which will come in the form of a VA decision letter. And like I said, it usually takes about 1.5 years at this point through the Oakland VARO for these claims to be processed. And once the veteran gets that VA decision letter in the mail, if they prevailed and everything is great and they got the rating that they were expecting, then that's it. They're going to start getting their monthly compensation check, and then they'll get that back pay to the effective date of when they file the informal claim. But say they get that VA decision letter and they're unhappy. Say the VA did not say that they had a service-connected injury, or say they did have a service-connected injury but they were rated too low. At that point, we can help the veteran, and the veteran has 1 year to appeal that decision. So sometimes we get clients through the clinic doors who are at that stage in their claim, and they want to appeal a decision that the VA has given them. So at that point, there's kind of 2 routes that the veteran can take. The first is to go back to the VARO and do another review at that stage with a senior adjudicator who does a de novo or brand new review of everything in the file. And the other route that the appeal can take is to apply to the next level of the appeal stage, which is to the BVA, the Board of Veterans Appeals, which we talked about earlier. Okay, so to go through some clinic logistics and what to expect when you're volunteering at the clinic. Here are our clinic locations. We have 4 currently, or we will have 4 very, very soon. The one we have now is at the downtown VA clinic in San Francisco, which is the 2nd and 4th Thursdays of every month. We're going to be starting one every Wednesday at Fort Miley, which is the big VA medical center in the city. And then the Menlo Park clinic, which will be starting December 3rd, which will be the 1st Wednesday of every month. And then the Palo Alto Medical Center clinic, which is the 3rd Wednesday every month, starting on December 17th. One thing to note about all of these is they're all located in VA facilities, which is kind of an incredible thing. We've partnered with the VA, and they've allowed us to use their facilities and to reach clients where they already are at, which is getting health care through the VA. And the other thing I just want to note briefly is the times are listed here for when the clinics are available to the clients. And we serve clients on a first-come, first-served basis as a walk-in clinic. But we ask that law student volunteers please arrive a half an hour beforehand just to do a brief training with us to go over all these logistics again before we start seeing clients. Okay, so one of the most important things that you all need to know working with clients is the rules of confidentiality that we all have to abide by. So I'm just pointing out here, this is Rule 3-100, which is the California Rules of Professional Conduct, which goes over the obligation that we all have to maintain confidential information of our clients. So you'll be getting information, doing intake interviews with clients. Obviously, you can share that information with the SWORDS attorney who's running the clinic and the pro bono attorneys who will be providing assistance, but that information cannot leave the clinic walls. We also can't, we need to be conscious of when we discuss client matters that we do it outside of the earshot of anybody who's working at the VA or other clinic clients. And obviously, if there's any issue that ever arises, any questions you have about that, immediately just ask any of the SWORDS attorneys that are working at the clinic that day, and we'll be able to help. Another thing to think about is what you may be running into clients. These are big hospital facilities, medical facilities. You may run into them in the hallways. You may run into them in public outside of the clinic area. And when doing so, it's good to just let the client acknowledge you first, say hi to you first, Don't approach the client, don't say hi, and initiate that kind of contact. And the reason is we'll be dealing with very highly sensitive information sometimes. Issues of discharge upgrade can be very sensitive. People dealing with PTSD, things like this. It's good to just keep the ball in the client's court. If they want to approach us, that's wonderful. If not, obviously don't take it personally. Their privacy is, we have to respect that. Another thing that we would love to have law students assist with is records review. And this is kind of the bulk of the work that we do at SWORDS and in developing a client's claim, and that's to go through medical records and military records for any evidence that would support their claim. So if you volunteer to do a records review for a client and go through and try to pull this evidence that would help them win their claim, obviously these are medical records and personnel records has highly confidential and sensitive information. It's always good to just not do that kind of review in a public space. Don't bring it to the library to review. Make sure you keep those files safe and secure at all times. And then, of course, we would in no way discourage you from discussing your experience of what you do at the clinic and how you are helping these veterans with other people. But, of course, when doing so, you want to maintain that confidentiality. Don't disclose any identifying information or anything confidential that the client has disclosed to you or that you've learned in the course of your work at the clinic. And then lastly, we just have an agreement that we have all of our volunteers sign, which kind of goes through what I've talked about. So the logistics of what to expect at the clinic. When a client comes to us through the clinic doors, we have a sign-in sheet where they write down their name, and we see people on a first-come, first-served basis. The first thing you want to do is when you see a client has signed up, just to go over to the client and explain to them what the clinic is, that we're here, we work at Sorts of Plowshares, where I'm a volunteer law student, and that we work on VA benefits and discharge upgrade issues, and that if you're not here for one of those issues, that we're happy to give you a referral to a different legal clinic or a different legal resource. Because sometimes folks hear, oh, there's a legal clinic, they come expecting that we're able to assist with a variety of legal issues when it's actually we just do these two discrete areas of law. So we like to phrase it like that and not call out whether they're here for a discharge upgrade or VA benefits issue. Just try to get a sense of why they're here, because we don't want people waiting in the waiting room for an hour to see an attorney if it's a child support issue or a housing issue, when really all we're going to do is be able to give them a referral anyway. So get a sense of what they're here for, give them a referral if that's necessary. If they are here for a VA benefits or discharge upgrade issue, then just provide an estimate if you can of the wait time until they're able to get in with an attorney. So before we do that, before you guys do that initial intake interview, we're going to ask that you check to see if the client has been to us before here at SWORDS. If they have been through SWORDS' doors before or have been to a clinic before, there'll be an entry in our case management software, Prevail. So we'll have a laptop set up at the clinic, and you can search in Prevail whether a client's been here before. If they have, then we ask you to print out any case notes that we have in Prevail and attach them to the intake sheet. So that way the pro bono attorney has a sense of what's already happened in that client's case. And so then you're going to do that initial intake interview with the client. And I'm going to review in a minute the intake sheet that we're going to have you fill out in your interview with the client. And then after that, we're going to ask you to check in with the SWORDS attorney who's going to be working at the clinic that day and see if we have any follow-up questions that we may have for the client before they go in to see the attorney. And then right before the client meets with that pro bono attorney, we're going to have the law students brief the attorney on why the client is here today, what their situation is, what their legal issue is. So this is the first page of the intake form. It's pretty straightforward, but I just want to point out some important things. That top portion, you're going to put your name and the date. The pro bono attorney, the firm, and the SWORDS attorney initials, that stuff the other people will fill out. We have a gray box here that says, is the client already in Prevail, and if yes, are the notes printed? That's really just to jog your memory to make sure that you've checked to see if they've been to see us before. And also the type of legal services requested, discharge upgrade or VA benefits claim. Obviously, if the answer to that is other/referral, then at that point you can kind of pause. You don't have to do the rest of the intake sheet, and you can just refer them to the appropriate referral. If it's a family law matter, bankruptcy, whatever it is, we'll have a list of referrals there that you can direct them to. But if they are here for an issue that we can assist them with, then we'd like you to fill out the rest of the form with the client. Contact information, pretty straightforward. Just so you know, sometimes the client may not have an address, sometimes the client may be homeless. A good way to ask these questions are, where do you get your mail? Or what is your mailing address? That's the kind of information we would need from the client. Also, sometimes clients have phones that go on and off, they run out of minutes, so it's always good to ask if they have an alternative phone number, perhaps a relative or a friend, just in case their phone doesn't work for whatever reason, we have another way of reaching them. And then, of course, email. Some clients have it, some clients don't. Then we ask some personal information and some income information, and we also ask, what is your current living situation? The reason we ask these questions is we want to gauge whether or not this client is getting all the benefits that they should be receiving and what benefits they already are on. So for example, a client comes to us, they're homeless, they're on VA compensation, and they get $400 a month, and that's it. Well, what does that say to the attorney who will be meeting with that client? Well, maybe they should be on food stamps as well, and maybe we should hook them up with a housing resource at Swords to see if we can get them housed. Sometimes clients, we ask these questions, they don't feel comfortable, they don't know why we're asking. If they ask why, just explain it like that. If they don't want to answer the question for whatever reason, that's no problem, just move on to the next, and that's not an issue at all. Next, we ask about military service. Again, this is pretty straightforward. The only thing to mention here, date of separation, that's the date that they leave the military. And the discharge status, it can be one of the 6 that Kate mentioned earlier. So it's not just honorable, dishonorable. It can be, general, other than honorable. There's a bunch. And then at the bottom, we ask about health and disability status. Very similarly to the reason above, we ask this to determine what eligibility or what benefits they may be eligible for, what benefits they're already receiving. All right, then now this is the back of that sheet. The top part is where you'll be filling out the brief description of the legal issue. This is just 1 or 2 sentences about why the client is here to see us today. So for example, they want information about eligibility for pension, for example, or they're interested in getting service connected for their PTSD. So just a brief description up top of what they're here about. The middle portion will be where the attorney, the pro bono attorney, will be writing out exactly what legal advice or assistance was provided to the attorney. And then at the end of the consultation between the client and the pro bono attorney, we'll ask that you retrieve this intake sheet and fill out this bottom portion. So this is actually probably the most important part of this form because it informs the Swords attorney who's running the clinic what kind of follow-up has already been done for this client and what still needs to happen for this client. So say, for example, a client comes to us, they've applied for pension, the pro bono attorney has filled out the pension application with the client, and now we need to file that application with the VARO. So we'll have you mark at the bottom of this form, yes, follow-up is needed, and then describe what follow-up is already completed. If there's a fax machine available at the time, then you'll be able to fax that pension application straight to the VARO that day and get it in. And you'll get a fax confirmation sheet with the date and time that it was filed. So you can write in that box, filed pension application with VARO. And if there is no fax machine or there's still work to be done, then at that bottom part you can describe what other follow-up is still needed, and that tells us here at Swords what we still need to do after the clinic for that client. So like I said, this is a very important part of this intake form. All right, so what are the follow-up procedures? So you get this intake sheet back from the pro bono attorney, the client is on their way, and now it's time to do some follow-up work. If it's possible, like I mentioned, you can file the applications with the VARO or any records requested via fax right there at the clinic. We'll have you next fill out the form closing letter, which I'll go into in a second. You'll want to complete the law student notes section of the bottom of the intake sheet, which I just reviewed. You'll want to photocopy anything that was filed on the client's behalf and staple those copies to that intake sheet so it's all in one place, including a copy of any fax confirmation sheets. And you'll want to put a copy of all of that, the stapled together packet, in the clinic folder for that date, which we'll have obviously at the clinic. And then you'll want to place the originals of anything that was filed, including the originals of the fax confirmation sheet, with the form closing letter in an envelope addressed to the client. And then when we're back at Swords, we'll mail that off to the client so that they have everything for their records. And then we also have a few opportunities that hopefully a few of you will take advantage of. Like I mentioned before, a big chunk of these cases falls in whether or not there's any evidence in the medical record or the military record to substantiate a client's claim. And this can be a pretty bulky task of going through, you know, a couple hundred pages of records to review to see if there's any evidence in there. So if anybody out there wants to take on a task like this, we'd love the opportunity or we'd love the assistance with any of this. So we have records reviews that we ask law students to do. And then sometimes clients come to us with pretty interesting, novel, and discrete issues that we've never seen before that require some additional follow-up research. So this is another opportunity for law students to help us out, doing some legal research to see if we can get this client some accurate and good legal assistance on something that we don't know anything about, or maybe we need more information about. All right, so this is the form closing letter that I was discussing earlier. It's pretty straightforward. You just write the date that the client came to see us. You check which of the which of the legal clinics they came to see us at, and then what it is that we have filed for them and how we have filed it. So my example again, going back, a pension application, you check pension application, you check that you sent it via fax, and then you enclose with this letter the original pension application that was faxed in and that fax confirmation sheet. Stick it in an envelope with their address on it, and then the SORD's attorney who's running the clinic that day will sign off on this and mail it off to the client once we're back at the office. Okay, so almost done here. We're just going to go over some of the main records requests that we do at the clinic. There are all sorts of records requests that we do, FOIA requests and others, but these are the three main requests that we see most often and do with almost every client that comes through our doors. So the first one is a VA medical records request. That's on VA Form 105345, and the pro bono attorney will help fill out that form with the client during their consultation. What's relevant for you guys to know is that when you fax out these medical requests, you'll need to fax it out to each individual facility. So for example, a client comes to our clinic, they've been seen at Fort Miley in the city, they've been seen at the Martinez outpatient clinic in the East Bay, and they've been to the Menlo Park division down in South Bay. If we're doing a VA records request, we're going to need to send that request to all three of those locations. Next, there's the military records and in-service medical records requests. That's on one form. It's called the Standard Form 180, and I'll review that in detail in a minute. But what's important to know about this is that there's a process to expedite these requests if it's a homeless veteran. So there's a special cover sheet, a special fax number we send it to. We'll have that available at the clinic. It's just good to be aware of in case you do see that we're sending off an SF-180 and the client is homeless, that there is this additional step we can do to help them. And lastly, we can request the C file or the claims file. And this is the file that the VA has for any past claims that the veteran may have filed before, so we can see, you know, what did the VA decide back then, what was the VA's evidence that they were looking at, and see what decision they came to. Because sometimes claimants come to us and they don't remember exactly what happened 10 years ago when they filed for that knee injury. So this is a way we can confirm exactly what it was that happened back then. All right, so this is the SF-180. This is the form you will be faxing that the pro bono attorney and the client will fill out. It's a pretty straightforward form, but the back of the form, which you will see is this grid to the right, is what you'll be using to determine where the where the form gets faxed. So you'll go by which branch the service member served in, the date that they were separated from the service, and then you'll use these right-hand columns to determine where to fax off the personnel record request and the medical records request. So you'll just go to the corresponding number, and at the bottom you'll see that grid where the location is that corresponds with that number. And we have fax numbers for each of these locations that we'll have available to you, so you'll know exactly where to fax off that request. Okay, I'm going to hand it back over to Kate to discuss cultural competency when working with veteran clients.
Great, thanks Mo. So I just want to take a minute here, and I will refer you, we'll email out these PowerPoint slides to every participant today, so you don't have to worry about writing down this link. But there is a veteran cultural competency video that I did recently available on One Justice's website, or there's a direct link there on Vimeo that you'll see. And I just want to take a minute and say, and so that goes into more detail, and I encourage all of you to watch that. In addition, Hour 4 of our PLI training also covers veteran cultural competency. So if you want to watch both, even better. If you can only spare 25 minutes, this is sort of the bare minimum. But for some of you, I'm sure you've had a lot of direct client experience or direct experience working with folks who are perhaps low income or people with mental health disabilities. And that's wonderful that you bring that experience to this clinic. However, I'm sure for some of you, this is going to be your initial or first experience working with low-income clients, working with folks with mental health issues. And so it's just really important to be aware of some things. You know, even if your intake interviews are only lasting, 5, 10, 15 minutes, there's some basic things to know. And one of those is that when dealing with clients who have been traumatized or are currently experiencing symptoms of post-traumatic stress, little things such as positioning, some people feel more comfortable with their backs against a wall or being able to face a door. It's nice to be aware of these things and to make sure that our clients feel as comfortable as possible so that we're getting the information we need to better advocate on their behalf. In addition, being patient with a client, so if they're, perhaps not speaking in chronological order or not remembering some key dates, or are really maybe saying some things that you're not quite sure how true they are or what validity they have, that's okay. We want to always treat our clients with respect, be patient, and just sort of give them the space and time they need to get their story out. Again, your intakes will be quite short, but it's still information that I'd like each of you to have and that will help build your client interviewing skills in addition to creating a more trusting relationship with the folks that you're working with at our clinics. So I encourage everybody to visit that site, to watch that video. And I just also wanted to say, there might be some moments during these clinics where if people are in crisis or are perhaps experiencing some severe symptoms, if anyone has a positive or negative experience or would just like to talk through what they experienced in that clinic, maybe they had an interesting interview with a client or maybe one that was upsetting for whatever reason, the SWORD staff attorneys, myself, Mo, or whatever other SWORD staff attorney will be there at that time, we're all open and ready and willing to sit down and talk either during the clinic or setting up a time afterward to sort of process some of these things. And I just want to put that out there that we're more than happy to do that. So that concludes our presentation today, the training today. We look forward to working with all of you and hope you can each make a clinic in the near future. I'm going to take a minute and we will resume with questions in just a few seconds.